Andrew Jackson was a states' rights man. He opposed the Bank of the United States because he felt it destructive of the rights of states. He opposed Henry Clay and Henry Clay's American system because he felt that destructive of the rights of states. He opposed the Supreme Court and its nationalist jurisprudence because he felt that was destructive of states' rights. There can be little doubt that Andrew Jackson was a states' rights man. But Jackson was also a Unionist, and as he waged a constitutional war against Henry Clay, John Quincy Adams, and the other nationalist Democrats, he also found himself engaged in a separate chess match with other people who believed in states' rights. This time, it was over the tariff. Taxation, as always, has been a measure of policy controversy. The Jeffersonians had left Hamiltonian taxation largely in place, although they reduced rates on many taxes. After the successful raising of tariff rates following the War of 1812, Southerners complained that the tariff was burdensome, especially since it taxed finished goods much higher than raw goods, essentially protecting native industries. Nonetheless, John C. Calhoun, the representative of the South, the great sectional representative of the South, supported the tariff, as did many Virginians. Opposition to the tariff existed, but it was hardly considered a serious issue, at least before 1825. There was a simple reason for this. The clause in question was the spending clause. The spending clause of the Constitution can really be broken into three different subclauses: the taxing clause, the spending clause, and then a restrictive clause. Congress is given the power to 1. Lay and collect taxes, 2. To pay the debts and provide for the common defense and general welfare of the United States, and these are respectively the taxing and spending subclauses, and the third clause requires that all duties, imposts, and excises shall be uniform throughout the United States. The tariff fell into the first part of the spending clauses. Internal improvements in the National Bank had more to do with the spending part of the spending clause, and involved an interpretive dispute over whether the phrase "provide for the common defense and general welfare of the United States" implied a discretionary power as to how to appropriate it. While strict and broad constructionists could argue about whether the establishment of a national bank was an implied power, or whether the spending clause enabled the building of internal improvements, no one could deny that the laying of a tariff was one of the enumerated powers of Congress. The only restriction on this was that they be uniform throughout the United States. In 1828, Southerners attempted to kill the protective tariff by amending it to sky-high rates that they figured no one would approve of. But when Congress passed the tariff anyway, to become known in the South as the Tariff of Abominations, Southerners found themselves isolated. It was enough to convince the longtime nationalist John C. Calhoun that Congress would have to be reined in. Secretly, Calhoun authored the Exposition and Protest, which the South Carolina legislature published as a pamphlet in 1828. The position Calhoun laid out in the Exposition and Protest conceded that the tariff was constitutional insofar as it raised revenue. But it refused the argument that Congress could use the taxing power to achieve any other policy aim. As such, since the obvious purpose of the tariff was to protect industry, this necessarily preferred one section over the other, and therefore one state over another, and was unconstitutional. So to be clear on this, come back here, the spending clause may have authorized the raising of duties in order to raise revenue. This is a constitutional use of the power. But he differentiates this from the unconstitutional use of the tariff to protect native industry. The exposition went further. When a state was confronted with an unconstitutional extension of power by the federal government, it became the state's duty to interpose itself between its citizens and the federal government. Now, this we should recognize as one of the principles of the Virginia and Kentucky resolutions, but Calhoun took this a very creative step further. A state, he said, could nullify federal law, but only by virtue of its sovereignty. And here he takes his cue not from the Virginia and Kentucky resolutions at all, but rather from the Constitution's ratification clause. If a convention of the people in a state declared a federal law unconstitutional, In other words, if the people were acting in their raw, unadulterated sovereign form, then the law was unconstitutional within the borders of that state. And then, of course, the only remedy to this was to overrule them by way of amendment. So it once again comes back to Article 5 procedures, both in terms of well, actually Article 7 procedures in terms of ratification, and then Article 5 procedures in terms of overruling a state in its sovereign capacity. Now, this contravened the orthodox opinion of constitutional processes in the antebellum era. As Jackson pointed out, there were essentially two remedies for the presence of an unconstitutional law. The first was to seek repeal by Congress, where the states and the people were both represented. And notice, by the way, that this suggests that the law which is passed by Congress has the stamp of constitutionality because the states and the people are represented in their distinct capacities. And of course, the president wields a strong check on this. If the president believes a law to be unconstitutional, he can, of course, veto it. The remedy here, if Congress does in fact pass and the president sign an unconstitutional law, is to seek repeal. And you can do so on constitutional grounds, to say that a Congress erred, and seek to have them repeal on constitutional grounds. The second, seek review from the Supreme Court. Although the states are not represented in the Supreme Court, this does reify the idea that the Supreme Court had a role to play in constitutional decision-making, and this comports, of course, with an understanding of departmentalism. It creates three separate branch checks, if you will, on congressional law in terms of understanding its constitutionality. Calhoun's theory of nullification has to be understood for what it was, a novel theory that went outside the mainstream of conventional constitutional thinking. It posited for the first time a real extra-constitutional remedy for solving disputes between two sovereign authorities. And it is genius for three reasons. First, it gave the states an integral role in deciding constitutional questions. The Supreme Court had been busy asserting its power to determine constitutional meaning over state courts and legislatures. Here you can think of Peters v. United States, or United States v. Peters, Fletcher v. Peck, Martin v. Hunter's Lessee, McCulloch v. Maryland, Cohens v. Virginia. This line of cases had significantly tread upon the state's authority. And notice as well here that the idea that the regulation of federalism, this is a major question, the regulation of federalism is to be negotiated in the national branches will necessarily privilege the United States government over that of the individual states. And here we have in Calhoun's theory a robust doctrine of state sovereignty, which it now has very, very tangible processes for solving these problems. Second, it engaged the tradition of the Principles of '98, and this, of course, refers to the Virginia and Kentucky resolutions. And this is a significant tradition in antebellum constitutionalism. You don't find it cited in Supreme Court opinions, but you see the Principles of '98 resonating with everybody during the time, whether we're talking about Democrats, whether we're talking about Whigs, whether we're talking about abolitionists, or whether we're talking about nullifiers. So the fact is, engaging this constitutional tradition actually gives Calhoun a lot more authority at the time, a lot less authority today. Third, it provided a solution that would avert secession, disunion, or civil war. We must read Calhoun's efforts within the context of the aftermath of the War of 1812, rather than as a prelude to civil war. Calhoun had seen the country nearly rent apart by sectional divisions during the war, when it was New England at the time that wanted to break apart the Union. Although Calhoun was more and more abandoning nationalism in favor of a states' rights interpretation of the Constitution, he nonetheless wanted to keep the Union together. To do so, he felt you would have to create a kind of constitutional remedy that would allow sections, the South, the Northeast, the West, pick your section, but would allow that section some sort of self-defense against an interested majority. And in fact, this is one of the things about Calhoun's thinking that people don't really know. He was an ardent Madisonian. He studied Publius, and in fact, his fellow states' rights Virginians, Thomas Cooper in particular, a famous law professor in South Carolina, despised Calhoun's thinking because they felt it too federalist, too Madisonian, not Jeffersonian enough, and certainly not connected to that Virginian school of strict construction. Nonetheless, the startling creativity of Calhoun's thinking must be critically received, and any theorist would point out the obvious problems inherent in nullification. It essentially prostrated the federal government, making the states in their individual capacity able to stymie any federal policy. This would fracture constitutional law, which would decrease its stability. And despite Calhoun's desire to avoid secession and disunion, the real problem with this theory is that it empowered precisely the agents in the federal system who could actually achieve secession and disunion. It is notable that the theory that underlay nullification would essentially be extracted and then shoehorned into a theory of secession some 25 years later, thus bringing about the end of the Founders' Constitution. So if Calhoun's stated desire was to develop a system which would avoid the horrors of secession and civil war, we must accept that he horribly miscalculated in this regard. There are two separate contexts to understanding the South Carolina Exposition and Protest, and I will suggest to you in this next section here that nullification and Calhoun's Exposition and Protest cannot be understood apart from these twin contexts. The first is connected to slavery and anti-slavery. From the Denmark-Vesey conspiracies uncovering in 1822 to the passage of the Negro Seaman Act and South Carolina's subsequent refusal to back down despite repeated admonitions from the Adams administration that its law was unconstitutional in 1823, to the emergence of immediate abolition and the success of abolitionists in Great Britain, South Carolina slaveholders were aware that they were more and more isolated. This is actually the very first immediate abolition pamphlet published in 1824, and then between 1828 and 1833, but this is really something that is ramping up between 1825 and 1828. Petitions are starting to flood into Parliament, and it becomes really the handwriting on the wall that slavery is on its way out in the British Empire. The tariff, it wouldn't appear, fits into this, but the timing is absolutely crucial. South Carolina goes from being a state which had led Unionist efforts, whose leaders were nationalists, to by the end of the 1820s being ardent states' writers, extreme states' writers. And this context must be understood. The Denmark-Vesey conspiracy, the idea that slavery was being threatened from all quarters, including by abolitionists eager to use state power to end the institution of slavery. All of this must be understood. There's also another context. The Tariff of Abominations of 1828 was the result of political miscalculation, to be sure. We'll require here that, or remember here, that in 1828, Southerners tried to make the tariff into an absurdity by pinning sky-high rates to it. Essentially the equivalent of, say, raising income taxes in America to levels, doubling or tripling the income tax. And then imagine everybody's surprise if such a thing were to actually pass rather than tanking it. This is precisely what happens in 1828 to Southerners. But this miscalculation made the election of 1828 a kind of referendum on the tariff, at least in the eyes of South Carolinians. It perhaps was a much larger referendum. John Quincy Adams was a strong supporter not just of the tariff, but also of federal expenditures on internal improvements, on the creation of a national university, and of other nationalist policies designed to knit the nation into into a nation, to, in other words, destroy state identity and create national identity. The subsequent election and victory of Andrew Jackson that November led many to believe that the tariff, much like the bank, was on its way out. Certainly, Southerners thought, Andrew Jackson would repeal it. But Jackson instead called for a reduction of the tariff, and Congress did reduce tariff rates significantly, by 1/4 roughly. But notice here that the reduction was a policy concession, not a constitutional one. the reduction in the tariff's rates still retained the tariff's purpose, which is to explicitly to protect native industry. As such, some South Carolinians still decried the tariff as unconstitutional, and now they begin demanding that the state take action to nullify the unconstitutional law. Tensions ran high going into 1830. In January, Robert Y. Hayne of South Carolina rose in the Senate to defend nullification and to deride as unconstitutional the remnants of the American system which had been Henry Clay's vision. Daniel Webster of Massachusetts rose to answer Hayne in what would become one of the most memorable senatorial debates in history. When Hayne complained that the East had always been hostile to the West and the South, Webster replied that the purpose of national policy was to build up the East and connect the different sections. When Hayne complained that national policy was fatal to state sovereignty and liberty, Webster memorably replied, "Liberty and union, now and forever, one and inseparable." Webster's words rang out everywhere but the South. To give you an idea of how tense things were, at the Jefferson Day dinner in April 13 in Washington that year of 1830, states' rights advocates dominated the toast, glorifying state resistance to the federal government from 1798, the date of the Kentucky and Virginia resolutions, through 1830. When Andrew Jackson rose to give his toast, remember Andrew Jackson, the state's writer, he somberly raised his glass and proclaimed, "Our federal union, it must be preserved." The room went cold. John C. Calhoun then offered his own toast. "The Union, next to our liberty, most dear." The relationship between Jackson and Calhoun thereafter went cold. Jackson, who prized loyalty and cherished union, considered Calhoun a borderline traitor, not just to General Jackson, President Jackson himself, but to the country and Union. Constitutionally, Jackson made clear that he believed the question of the tariff to be an easy case. The power, this is Calhoun giving his toast, the power to impose duties on imports originally belonged to the several states. This is from Andrew Jackson's proclamation on nullification. The right to adjust these duties with a view to the encouragement of domestic branches of industry is so completely incidental to that power that it is difficult to suppose the existence of one without the other. The states have delegated their whole authority over imports to the general government without limitation or restriction, saving the very inconsiderable reservations relating to their inspection laws. He went on to say that if the right to exercise this power, protecting native industry, lay not with the federal government, then it was in fact extinct. Jackson's position was more or less borne out by a fairly simple reading of the Constitution, according to the normal rules of construction. If you dissect his statement, this becomes clear. First, he gave the document an historical gloss. The power of tariff collection was an incident of sovereignty, and the states had delegated that power to Congress. One could reasonably infer from this that the states had intended to pass the whole power over to Congress. The only reserve power, he concluded, was with the inspection laws. If so, then the discretionary power to use the tariff to protect native industry was an incident of the power to collect customs. It was therefore a constitutional exercise of the taxation power. Now this, by the way, notice the connection here with the Negro Seaman Act and with the southern states' emphasis on keeping free blacks out of their states. This is a big concession to that, and actually Roger B. Taney, who is Attorney General, will pen an opinion, although it's never published, stating that the Negro Seaman Act is not unconstitutional, that it falls within the constitutionally permissible bounds of the federal union. So there's a shift here. Once again, Andrew Jackson shifting towards states' rights, but he puts his foot down on this because this involves too much latitude of construction on the part of John C. Calhoun. Jackson, by the way, would urge and continue to urge a downward revision of the tariff. But this, again, is a policy goal, not a constitutional goal. The power, Jackson believed, was clearly a constitutional one. And because the people had continually showed approbation for a protective tariff, Jackson was unwilling to veto the tariff on constitutional grounds. Jackson did believe, after all, in majority rule. Jackson would win the presidential election handily that year, but with a new running mate, Martin Van Buren of New York. John Calhoun would resign his position as vice president. Here's Calhoun. He would revise his position as vice president on December 28. He became the first major public officer to resign his position. This is about 2 months. This is December 28, 1820. It's about 2 months before his term actually expired. He goes back to South Carolina then to help out the state. His home state, meanwhile, had doubled down on nullification. Despite the compromise that had produced further reduced tariff rates, a good contingent of South Carolina's population were ardently ready to stand on the constitutional principle. On November 19, 1832, a convention met in South Carolina, elected by the people, and it passed an ordinance of nullification. This nullified the federal tariff and prohibited federal officers from collecting duties in South Carolina ports. The crisis had arrived. In his message to Congress on December 4, 1832, President Jackson made 2 references to the crisis. First, he called for a substantial reduction in the tariff. From a policy perspective, the tariff had accomplished its goals. The national debt had virtually been retired, and protection was only necessary as a matter of national security. He also issued a proclamation directed at South Carolina. It decried nullification and secession, and warned them that to attempt such things was treason. Jackson was backed by Congress again, as it passed the Force Bill in 1833, which gave him powers to enforce federal law. The passage of the Force Bill is but one indication of how isolated South Carolina was in 1833, very much like Pennsylvania in 1809, or Virginia and Kentucky in 1798. No other states came to South Carolina's defense. Nullification sentiment was contained in 1833. But this did not mean that Jackson had checkmated the nullifiers. Quite the contrary. He had pushed his pieces too far and too quickly, forcing a confrontation over the tariff that was now wrapped up with his own personal honor. He blustered that he would collect the tariff at the point of a bayonet if necessary. He threatened to hang Calhoun should he return to Washington. Jackson was pushing towards confrontation in a way that appeared reckless. After all, the support he received against the nullifiers had not been tested in the face of actual coercion. Meanwhile, Henry Clay negotiated a compromise that allowed for the tariff to be retained, but gradually reduced. The compromise bill was too much for the Middle Atlantic and Northeastern states, which opposed it, but it was supported by the Southern and Western states and thus passed Congress. For its part, South Carolina held another convention in which it nullified the Force Bill. Given that the tariff crisis was over, this was primarily a symbolic gesture. It, too, had its precedents. It recalled 1766, when Parliament repealed the Stamp Act, only to pass the Declaratory Act. Or even 1803, when John Marshall declined to force the executive to turn over Mr. Marbury's commission, while still asserting the principle of judicial review. And so in the end, we are stuck with an ending without resolution. On its face, everyone got what they wanted. Andrew Jackson's Union was preserved. He had rejected nullification. South Carolina had upheld the principle of nullification and achieved a massive reduction in tariff rates. Henry Clay had salvaged the tariff as a constitutional means of improving the national economy. That principle went unsurrendered. But the paradox of everybody getting everything they want was that no one won. Could states interpose to block federal law that harmed their interests? Could they nullify the law? Could the federal government coerce the states to follow federal law? These were questions that would continue to haunt antebellum actors as they negotiated the Founders' Constitution. And so we must conclude that the nullification crisis ends in stalemate.